Thank you, John. Thank you. Welcome everybody to the webinar and thanks for attending. I want to try and explain this quite complicated navigating hybrid cross-border employment. Hopefully at the end of it, you'll have a good idea of how it all works, and hopefully it'll help you all in the future. Cross-border solutions. Well, who are we? First, we're a very small business. We're based in Uri. We're in the cross-border advice board nearly 20 years, and we're financial advisors by our profession for nearly 30 plus. Well, it is 30 plus years now, scarily. But we work alongside our local accountants. We work with government agencies and the likes of Interest Rate Ireland here, who do a great job in the cross-border world and trying to get everything kind of understood for people. We also work very closely with the advice sector, and that would be the likes of the cross-border partnership and the government agencies. And cross-border partnership will be run by Barbara Gibson, and that's the Department of Social Protection, Department of Communities link, and they come together through the cross-border partnership to kind of bring mobility and employment cross-border and to try and put jobs in place. So we do work with them through the Dairy Chamber for Anna and Emile, and through the Dog Chamber of Commerce for Brenda and Paddy, and do a lot of talks and advice and help for them. And we also work closely with the Centre for Cross-Border Studies and the Border People Project, which is maybe, if you're on the website there for the Border People, you would see it. And that links in with his information. There are cross-border experts in Manus and Aden, south of the border, and we would work with community advice north of the border, which would be Aisling based in Uri, and Jackie's in Fermanagh. And also the likes of employers for childcare, which is Chris there. So when you see the kind of range of people we deal with, it is about the holistic side of things. We're putting everything together. So it's from the point of view, if it's an employer trying to work out, should he take somebody's workforce and take them into a contract across the border? Should it be flexible working? Should it be hybrid working? It's looking at the whole situation. It's looking at everything. What happens with the employer, how it affects the employer, how it affects the employee, and how it all works, and does it work, and what needs to change maybe to make it work right. So a lot of the time, like Interest Rate Ireland, we will signpost on to maybe who are the right people are, and it could be maybe financial advisors in the other side of the border from yourselves to figure out, well, what happens to your pension, or what happens with auto enrollment, or how all this will come together. So we kind of bring a lot of expertise together in what we do. We don't necessarily know it all ourselves, but we know the right people who do, and that's really been our function for quite some time. It's trying to make sure that the right decisions are made, and made early before there's any issues arise. So on today's agenda, I'm going to be speaking to you about the hybrid working, and it can be hybrid working, it can be flexible working, it can be remote working, any of those. We're living in another jurisdiction, and what you need to know, and also now who do you pay your income tax to. So it's from the point of view of an employer and the point of view of an employee. We'll then also address PRSI or National Insurance payments. So in Ireland, it's going to be one or the other, and what happens and how that's determined. Also, we have the Social Security implications. From the employer point of view, it's the where he makes his payments to, and then who he pays on behalf of the employee, to where they would then be entitled to anything, and how that all works in to making any of these decisions. And lastly, and very importantly too, it's the legal implications. What happens from a legal point of view for somebody who wants to work in the jurisdiction away from their employer, so outside of their country of the employer. How does that work from a contract point of view and from a law point of view? So we'll touch briefly on that as well to kind of give a good understanding. So I think, as you can see from this, we're really trying to give a very sound kind of set of recommendations, and here's the whole picture, and here's what we need to look out for, what you need to be careful of, and to bear in mind when these decisions have been made. Now, why this has all come about, I suppose, and it's all come from COVID. And during COVID, because of health and safety, and that a lot of people were told to go and work from home, those flexible arrangements made. Work had to go on, and people found it very content not to be travelling to the cities, and maybe a lot less commuting. There was saving travel, there was easier for childcare, it was less parking. Companies then thought this was great. There was less people in the office, rental costs were reduced, so could downsize, and a lot of things were working very, very well. And it has changed our whole trend to flexible working, to the use of local hubs, maybe along the border, different way of working, a whole new way of doing it. And with this technology that we're using today, for example, 6, 7 years ago, this would have been unheard of. Where nowadays it's very much the norm. So hooking into meetings from all over the world is a very, very normal situation. But with this comes the complications of the rules and the regulations. And while they were perfectly okay during COVID because there was a change in the rules and employers and employees were allowed to have the flexibility, that changed from April 2022, really, when normality, as we call it, came back into place. And it meant that the regulations that are in place pre-2020 are what's in place again. And they were never really designed for this world that we're in. And if we look at the typical frontier worker on the island of Ireland, they're travelling maybe 5 miles, 10 miles, 15 miles to work across the border. Some are maybe travelling 60, 70 miles, but it's very often a short journey to cross the border. So the flexible working continued on after the regulation changed back, and nobody was really aware of exactly what the rules were. They weren't something that were on the agenda pre-COVID. And people would ask me here, well, did Brexit have a big effect on the employer employees and crossing the border? And we would say, no, actually COVID had a far bigger effect. And that big effect was because it brought to light the flexible working, the hybrid working, and has really meant that there's been a lot of rules have now to be changed and adjusted to allow people to do that without falling foul of them. And the rules, I have to explain that they are complex when we're dealing with hybrid arrangements, because, as I say, you could be leaving Clonus to go to Roslea to work. You could be leaving Derry to go to Buncrana. It's only a few miles up the road, but you're into totally different rules and regulations. And the rules are really, of mobility rules, are worldwide rules and are global rules that don't fit that well for somebody who's driving 10 minutes down the road. For somebody who is literally done something all their lives, up and down the road, and to think nothing of it. We would be very much say to people that you have to think every time you go to work cross border that you're going to work in Spain or Italy. It's not just down the road. The rules are the exact same if you're getting on a plane as they are just driving down the road. There is no rules that fit in nicely on the island of Ireland. There is no system in place to say, oh no, you'll be okay. It doesn't happen. And I think in part this is what the issue is. We do find it so easy just to drive down the road or pop into work, or we can do everything without really noticing the bother. But the rules don't work like that. And the EU and the governments and the likes of Intertrade Ireland are all working hard at the minute to try and alleviate these issues and trying to come up with ideas of how to sort it out. There was 2 years ago now, I think it is, the EU called together a lot of interested parties to see what could they do to change some of the rules to help people in these situations, and there was different modifications on that done, and the EU said, well, country to country can make different decisions if they want, if it helps them. And the EU's premise is mobility and mobility of employees to work across borders, and so there's a lot of work going on to help that. But here's the but, I suppose, starts. Once an employer makes a change to frontier workers contract, it has implications right down the line of all the different areas we've been discussing, and its implications on payroll, its implications then on the social security for the employee, and on the legal rights. So any kind of changes can knock everything out of its norm. And these changes happen very, very quickly in these circumstances. There is no big lead-in periods, or there's very little leeway within the rules. And that's really because they are global rules rather than local rules. So from an employer perspective, you have to be very, very careful if you're considering changing your workforce and having them working from home and downsizing and deciding, no, this would be a great idea, and we can just implement these rules and it suits the business. You have to be very careful, because with workforces nowadays and with employees, they're very valued, and that there is a shortfall, and good quality employees really need to be taken care of, and have to be protected. And the better that you can protect them and give them the right advice and give them the right levels of support, the better decisions can be made. And that means that employee should stay with you. And they'll also understand why you're making the decision, because it's impacting directly on them. So, and what we're going to start here is kind of explain how to correctly employ a hybrid worker, what you're meant to do. And this is an example of Mark. And anybody who knows my world, I like to deal in scenarios and situations to give an example of how it would work, because everybody comes through to me, it's their situation, and that's how we try and rectify it and fix it and advise people. So, and this is a simple situation with Mark, and he lives in Uri, so he's in the north of Ireland. He's working 2 days from home, and his employer is based in Dublin in the Republic of Ireland. So what his employer has done is set up what's called a shadow or a dual payroll, and it reflects the 2 days work that he's doing from Uri, so from his home. And that would mean that for those 2 days a week, he'll be on payroll through the HMRC, paying his tax to the HMRC for those days. For the 3 days then that he's working in Dublin, he's in a different country, and so he pays his taxes to the Republic of Ireland for those 3 days. So we know, to have Mark working correctly, he has 2 payrolls, and his employer has to run the 2 payrolls, has to pay him through these 2 payrolls, and has to then pay the taxes to the Irish Revenue and to the HMRC in real time, so that everything is correct and right. In this situation, then Mark has to complete a tax return to the HMRC, because that's where he's living, at the end of each tax year. And this then potentially can lead to a tax bill for him, because when the shadow payroll is completed, there is tax being deducted on both sides, but it's not necessarily the maximum tax that should be deducted. Whenever Mark does his tax return, he'll declare the amount of tax that he has now paid between the two. And an example, if Mark was earning €100,000 and had been working 5 days in the Republic, Revenue will have taxed him on €100,000. So he would have passed the 44,000, 20% tax, and 56,000 at 40%. And normally, if he's been taxed as a single person, he would have paid more tax in the Republic than was owed in total in the UK, so he wouldn't have an additional tax bill to pay north of the border. However, in this circumstance, it could be that 60,000 is paid for the 3 days in the Republic of Ireland, 40,000 is paid in the 2 days through the HMRC in the north. So both are taking their tax on that basis. They're not taking the full amount of tax, so there's potential for a tax bill. And that tax bill is Mark's bill, because Mark's got the advantage of not paying as much tax as he should have, and he has a liability to the country of residence. And that would be the same situation if Mark was living in Dublin and working 2 days a week or 3 days a week in Uri. He would have a bill to the Revenue at the end. Sometimes in these situations, an employer might then try to rectify the situation, but by trying to do that, in that he would essentially loan Mark the money for the tax that's owed. That then can be seen as a benefit in kind as well, and can end up with more tax implications. So it's quite an awkward one to square. Sometimes we would advise maybe to have an overpayment of tax, maybe to Revenue in the south or to HMRC, to accommodate the fact that this is going to happen on a live basis. But this is a typical shadow payroll, 2 payrolls, 1 on each side. Issues from Mark's point of view here is that it's quite complicated now all of a sudden, because his net take home is going to be different than what it would have been previously, because he's running on 2 tax systems. He can have a tax liability now in the Republic because his worldwide earnings are now 40% in the UK, which impacts on the credits that's available to him in the Republic of Ireland. If Mark was then considering looking for the likes of a mortgage, the mortgage company mightn't accept the fact that his income coming from 2 different payrolls. So there's lots of things can kind of get complicated with it, but this is the typical situation that you should be doing if you are working on a 3-day, 2-day split, something like that. Now, the with paying tax in two jurisdictions, there is issues when you're trying to set up a second payroll. And that issue is the employer's issue and how to do it and how to put it all together. It's not simple. Like nothing cross-border generally is. There's also then, if Mark decides that he's going to work 5 days a week in the north of Ireland and not working at all in the Republic of Ireland, well then it's a single payroll, and that payroll will then be in the north of Ireland. So 100% of his income will be in the north of Ireland, and there will be no income from the Republic of Ireland. And in that context, the Republic of Ireland would then totally detach as far as Mark's concerned. His taxes should be correct in respect because he's paying 5 days a week into HMRC, and his tax code would reflect that. So being 100% in either is certainly more straightforward than having a system where you're footing both sides as such. From an employer, there's additional costs, there's expenses. He has to fund the second payroll. How do you fund it? How do we get the payment through to HMRC? How do we pay any other liabilities to them? So it'll be additional costs for accountancy costs, payroll costs to run that. There's complications as well arise because the tax year in the Republic of Ireland is a January-December tax year. A tax year in the UK, of course, is April-April. So you're running two different types of tax year, and you're trying to balance everything off. And that's in a simple situation, in fairness, that it's a 3-day, 2-day split, which if that was continually happening all the time, it would balance out and you'd say, right, I can get used to this and this works. And month on month, the payroll will be the same. However, more often than not, and it's certainly when we look at our bother here, the work pattern could be a lot more erratic. It could be in 1 week, maybe Mark has a first meeting in Belfast in the morning. He's then in Clonus in the afternoon. He could be in Dublin and he could be back to Newry. He's crossed the border maybe 3 or 4 times. So there can be erratic work patterns. He could be 4 days this week in Dublin. He could be 3 days next week in Dublin and 2 days in the following week. So when there's changes, it's then very, very hard to accurately run the payrolls. How do we know what percentage of time was in each jurisdiction, and how then do we calculate out the taxes, and how does it work? So a straight split is good, but more typically it's going to be more erratic, and that is very complicated then from payrolls. And this is where we would certainly recommend the services of our local accountants, in that local accountants generally are fit to do the payrolls from both sides of the border, and they'll typically be fit to do both, and they're probably best placed to try and monitor what's happening and how to make sure the taxes are compliant on both sides of the border. But it's certainly a serious issue to make sure that everything's compliant. The within the rules as well, there's often we're sort of looking for solutions, and people are saying to us, well, can I not do this, and can I not use these rules? And one that comes up regularly is we call it the 60-day rule. It can be the 30-day, it can be the 60-day. And this is where employers would say, well, can he not work 1 day a week in the north of Ireland, Mark, because he's inside the 60 days, and that would mean that I don't have to run the payroll north of the border. I can keep him in the south of Ireland and have him 100% of the time. But the rules that they're referring to, the treaty rules here, do not work for somebody who is going back to work in the country they live in. And this is a huge difference in this. And I'll explain it in that if Mark was working for his Dublin employer and that employer said, Mark, we need you to go to Madrid for 2 months and work in Madrid for us, that's perfectly okay with the 60-day rule. No issue at all. His PRSI can stay in the Republic of Ireland. His taxes can stay in the Republic of Ireland because he's inside of the rules. The first day that he comes back to work from home in his country of residence in the north of Ireland, those rules do not apply. The payroll is required from the very first day that he is working from home. And it's a huge difference. We're also asked about, well, does this rule not work and that rule, and that there's a 25% rule, which we'll come to shortly. Anybody who's working from home in either jurisdiction are to be on the payroll from the first day that they're doing that job. There is no grace period. There's no 30-day, 60-day period. And so it's something to be very, very careful of. And again, this is where proper planning, working out exactly what has to happen, rather than kind of letting it run and then seeing where the issue is and trying to fix it. Have a plan in place early. We have auto enrollment now on both sides of the island, on both sides of the border. And so there is statutory requirements with regard to auto enrollment, with pension payments. And so if you're running a shadow payroll and you have somebody who is on both sides of the border, you have to then be very careful that you're not going to fall foul of any of the rules linked to both sets of auto enrollment or normal pension contributions. Also within that, most employees will have some form of employee benefits. They might have death in service, they might have sick pay, they might have an income protection plan, they might have healthcare. So whenever you then change your payroll, that you have a payroll on both sides of the border, it has to be worked out, well, what happens to pension payments? How can they be properly taken care of? What happens if there's an income protection plan through work? Will it cover the employee because now they have sterling income or maybe now they have euro income as well? Will dual payroll fall into that? If they're off work sick, what happens there within these rules? Will their healthcare benefits carry across to the other jurisdiction? So what's very straightforward when you're working in one country becomes very complicated when you're trying to do both. And being aware of the issues allows better planning, better preparing, and also better explanations of what has to be done. One of the issues with setting up a second payroll is that because that's in a different jurisdiction, you may not satisfy all the rules to set that payroll up. A simple thing like a national insurance number could be required from the company. There mightn't be anybody with a national insurance number. How that's actually set up and how it's run from that point of view is quite difficult. Right, take a wee breath there a second. Different set of rules now to consider is linked to corporation tax. So the permanent establishment rules. And what really this is about is from the employer's perspective. If, again, we'll take Mark again, and his employer's in Dublin. Mark's based in Uri 2 days a week. If Mark's place of work, as in his home, is considered a branch, is considered a place of work from the employer, the Dublin employer could potentially have a corporation tax charge to the UK. And this can come about because he'd say, well, Mark's making decisions in the UK, he's doing different work that means that it's an advantage for him to be there. So this is a branch, so you'll have corporation tax charge. So essentially, employers have to be very, very careful that they don't fall foul of the PE rules, as they're called, the permanent establishment rules. And very, very recently, it's really just hot off the press, the OECD have clarified some circumstances now and have come in to kind of give a good explanation of where these rules stand as regard working from home, frontier workers, people in our situation here on the island of Ireland. And it was as recent as November this year, not this year, well, November 25, that they met and have agreed to changes. This was published, I think, just in January. So it's very, very recent and very much in keeping with the modern world. And what they were trying to do is establish when the PE rules would kick in and when they wouldn't. And the three areas really they're focusing on is that there's a commercial reason for the activities that are undertaken. So what is Mark actually doing when he's working from home or a relevant place? So the relevant place for Mark could be if he's using a local hub in Uri, or if he's rented a wee office or something, is a relevant place. They then look to see what the fixed place of business is on a continuous basis as far as Mark's concerned. And this is where they're trying to clarify, well, if somebody was using a holiday home, if they're working 9-10 months of the year in Dublin and then they take a holiday home in Spain, is that seen as a fixed place of business on a continuous basis? So that they're trying to rectify the different definitions and trying to make it more precise. The 50% rule, which is a huge part of this, is now being introduced. And in its essence, they're saying, well, if it's less than 50% of your time carrying out your work, they tend to discount it. If it's more than 50%, they'll then look to see, well, the commercial reason and the fixed place of business comes into play. And what I mean by that is, if, for example, Mark being based in Uri meant that there was contracts coming to the company because a company in Belfast could link up with Mark in Uri and could use Mark basically because he's here in the north, and that's the reason they were getting the business. That's a commercial reason. It's a commercial reason because that business wouldn't have happened if he was back in Dublin. A bit of clarity then to say, well, the employee's home is actually, well, it's his home first and foremost. It's not an office and it's not a business. People are entitled to work from home, then there's no issue with working from home. And they'll make the distinction to say, well, the employer, so Mark's boss can't come down from Dublin and decide to set up his office at Mark's kitchen table and invite clients in to see him at Mark's house. Because the first reason that Mark's in his house is because it's his home. So, and it's a good definition, I think, in that your home is firstly your home. If it was a case then that Mark was over the 50% of the time, that there was a commercial reason that Mark was in the north for a company south of the border, and that was seen as a fixed place of business, then permanent establishment rules would be in play. And that would mean that the corporation tax charge would be in the UK for the Dublin company. So I think it's well worth having a look. Anybody who's interested in the updated rules, it's in the 2025 update of the OECD Model Tax Convention. If you Google it, you'll get all the information. I think that's compliment to them, in fairness. Reading through all of it, it's very clear and it's very precise, and it has some really good examples of what works and what's outside of the rules. Now, another wee breath, different area. We're now looking at the situation where we've left the payroll as far as tax is concerned, and we've discussed the taxes. We've looked at it from corporation tax to whether Mark then being based in Uri is going to mean that there's a PE charge. We're now looking at the situation where we have to decide, is it PRSI, so that's the social insurance contributions in the Republic of Ireland, or is it the national insurance in the north of Ireland? Which one is it? And how do we decide on what has to be paid? So a document I regularly take a few hours to read over just to keep me happy is under EU Regulation 883/2004. And this will dictate which option you must take. Employees can't decide, oh, I want to stay in PRSI. No, I want to stay in national insurance. Oh, this suits me. I'm going to have this option. You cannot decide that. This decision is made through these rules and through the regulations, and it's black and white. It's either one or the other. And it's the 25% rule that I spoke about earlier. So this is where the confusion sometimes comes with when we're doing talks and speaking to employers and that, and they're saying that, oh, well, surely the 25% rule, Mark could work from home 1 day a week. And then we'd have to explain, no, he falls into the other rules and he can't work from home without the payroll in the UK. So Regulation 883/2004 on the coordination of social security systems states that an employee working more than 25% of their time in their country of residence, so where they live, where their home is, shall be subject to these social security rules. And that basically means that in Mark's situation, he's 2 days a week in Uri and he's 3 days in Dublin. He's been paying PRSI contributions into the Southern system, so he's been paying that to the Department of Social Protection for several years. That now has to stop, and he has to start paying national insurance to the UK. Any PRSI benefits will stop, and there will be no deductions at all as regards PRSI. You can only pay into one country at a time, so there is no liability at all in the Republic of Ireland. It is 100% in the United Kingdom. Whereas there's a tax liability to both jurisdictions, both countries are entitled to take their tax. It can only be one country for social insurance. And that's because that country is then responsible for paying any kind of social security payments to Mark and potentially to his family. And this is where the big difference is. Two countries cannot pay you at the same time for the same benefit. In respect of, there has to be a decision. There has been movement and changes, and I was saying about the meetings in with the EU, and there has been an increase with several countries from the 25% rule, and it's allowing more mobility. So somebody maybe fit to work 40% of their time in one jurisdiction, living in one jurisdiction and working for another one at 40% of their time, and still entitled to retain their benefits. Unfortunately, in regards to the island, we have no increase between the UK and the Republic of Ireland. It's staying at 25%, which has meant that we would be, I suppose, harder done by, to put it in one way. It would probably be easier if it was between Ireland and Spain. There might be a higher margin, or Ireland into Europe, or Ireland and UK. It's the 25% rule. So it's very, very tight, and it means that if there's more than 25% of your time is working from home, you have to be paying the social insurance of the country you live in. Now, huge impacts. So if we look at a situation where an employer has brought in his workforce and has said, okay, we're changing our policy and we are taking 20 of our staff, and we want them to work from home from now on, and they're going to be moving from our workplace in Clonus, and they can go back to work from home in Russellay. So 20 people are then adjusted, and it's all changed over, and they're put into either 100% of a UK payroll. They're putting on a 3-day, 2-day a week. Both of these situations would mean that their PRSI would stop immediately, and the national insurance contributions would start. So once that national insurance contribution starts, it impacts on all their social insurance, social security entitlements. The first one of those is state pension. A lot of cross-border workers will be very aware of their state pension and that what it takes to build a state pension, because they're going to be working on both sides of the border. You have to have a minimum of 520 contributions in either to once you get into that pension. If you're moved back to a contract in the UK, your PRSI contributions stop, your state pension contributions in the ROI stop, and they go to the north. And an important on this as well is that if you then died, you don't have an entitlement to a widow's pension. Your widow doesn't have a title, or a widower to the widow's pension in the Republic of Ireland, because they're not paying the PRSI there. And it's an excellent benefit in the Republic of Ireland. So that's lost. Children's benefits, this is the likes of your child benefit. And child benefit's based on paying PRSI or national insurance. If in this situation of Mark's, he's 3 children, he's getting an additional approximately €100 per month in child benefit from the Republic of Ireland, and that would stop. In Mark's situation as well, he has a disabled child and has been fit to claim domiciliary care allowance in the Republic of Ireland, which is an extra social security benefit. That stops immediately too, because that's based on PRSI being paid in the Republic of Ireland. The statutory sick pay. Statutory sick pay is now in the UK, because that's where its national insurance contributions are, and any payments are based on the statutory sick pay rates now in the United Kingdom. And within this context, if, for example, Mark was unfortunate enough to have just crossed the border a couple of months and taken sick, he won't have enough national insurance paid to pay for a statutory sick pay. And what will have to happen there is that the PRSI will have to be taken from the Republic of Ireland and sent to the United Kingdom to provide that payment, and that could take 6-7 months. So in this situation, then he could be financially in a very, very poor state, as well as not being well. He's actually financially very, very unwell. Redundancy payments. When we look at redundancy payments, you're looking at your statutory redundancy payments. The rules are going to be completely different in the Republic of Ireland than they're going to be in the north of Ireland. So it has to be then worked out, well, what happens in this situation? What's going to happen? What happens if the company goes bust? Or what happens if they just want to make redundancies? How would them calculations then be completed? The bottom slide here, the maternity and paternity benefits. If we had a situation where a lady was about to go off on maternity, maybe in 3 or 4 months' time, and she was switched to the contract where there was national insurance paid, she would then have no entitlement to her maternity benefits in the Republic of Ireland through the department, because she's not paying into that system. She's not in the PRSI system. Whenever she would go to apply for maternity benefits, those maternity benefits would have to come from the north. So the UK would be responsible. And in the same, any paternity benefits, the rules and regulations for paternity benefit would now fall into the United Kingdom's rules, not what they were previously used to in the Republic of Ireland. And these are only some of the areas, and they're huge areas. And anybody listening here, all these areas will be affecting yourselves personally. And from an employer point of view, these are the areas that you have to be very careful of when deciding whether either A, to allow an employee who requests hybrid working or working from home or flexible working, whether to allow them to do it and to explain to them what happens. And from the other side of it, if you're deciding to move your workforce across the border, there's implications here as well. And when we talked about the shortfall in talent at the moment, that everybody's pretty much at work, it's difficult to train up new talent. It's difficult to recruit new talent at the level maybe you want. Any employees that are there at the moment, you need to be very, very careful that maybe you don't cause an issue and then they decide they're not going to come and work for you because as they did decide to move, or you decided that you wanted to make a move and change your workforce around. So I think it's something to be very, very, very cautious of. Now, in fairness, the employer in these situations is not going to be aware of all the Social Security entitlements an employee would have. It's not their concern in that they want to pay them their wage, they'll pay their relevant PRSI or National Insurance. It's confidential to the employee. So it is difficult then to work out, well, how do we make the employees aware of this? How do they understand where there could be implications? So we would recommend that any employee that's either requesting a change to the hybrid method, that there should be a process there that to say, well, hold on, we think you should check out your own situation and see from your personal situation, is this something you should do? We would recommend the use of a checklist, even the list there that we have. Will any of these be affected? What happens? And an explanation maybe of the change that it's going to be PRSI instead of National Insurance or vice versa. And let them either go and get the advice. They can come and speak to cross-border advisors like ourselves. We can work out exactly what their situation would be if they did move, or would they be better off staying in the position they're in. It's a huge area, and we're finding that more and more employers are now becoming aware of this and are looking to safeguard their employees and protect them, so that they want them to be doing what's best for them, but also not losing out on any of the entitlements that are there. And many situations now with cross-border work is very complex, and it's complex in that there could be health needs in the family. There be maybe a one-parent family. There could be a divorce situation. There could be somebody widowed and maybe trying to bring up the family. There could be care responsibilities. There's so many situations behind the scenes, and it's important for the employees to be aware that these will all be impacted by any changes. And I think if any piece of advice today, I think it's employer and employee have to have their responsibility, and the employee is very much responsible for making their decision and going and getting the right advice. And I think if the employer can lead that and help them to do it, be it their HR department or if they have any kind of direction that can be given. And any of the groups even we've talked about here today, but can also help to make sure that decision is the correct decision to make and stays within all the rules and regulations. And in this situation, we're really looking to say, well, that nobody then is losing out. It's a good decision. It's well made. It can be a great advantage to move across. It can suit in a lot of ways. And it's just making sure that, I suppose, I's are dotted and the T's are crossed, that everything is okay and it works. And there is different situations, and that we would, when we're looking at with employers at their workforce and saying, well, a bit flexibility or a bit maybe setting up in a different jurisdiction and moving some of their workforce across. It is possible to say, well, if you had 20 employees, a single person at 23 or 4 years of age is not going to have the same issues or concerns at changing contract to a Republic of Ireland contract, for example, from the UK, because it's not any way detrimental to them, and it might suit them. Whereby somebody with care responsibilities would have more concerns about doing it. And sometimes, in truth, it actually could be a big advantage to change their situation. Somebody near a retirement, you're then looking to see, well, what way would this impact on your state pension, your pension benefits? What happens there? Maybe somebody who has care responsibility for their spouse, and maybe they're terminally ill. Should there be any changes there? How would that impact? So there's so many situations that a wee step back from, I suppose, the day-to-day work and say, right, let's figure this out properly and make one decision and do it right. And I think in that, when it's done in that context, the employers retain their staff, they keep their quality staff, employees feel valued and want to stay working for the company because they've seen that there's more value with the employer. Now, that's just really what we've run through there. Now, what we would highly recommend in situations where it's maybe going to be complicated for the employee to change is for the employer and the employee to have a more flexible approach to this situation. And what we mean by flexible approach is that try and see, well, is it possible to stay within the jurisdiction of the employer? So we'll talk about Mark again, where Mark lived in Uri and was working 2 days a week. But if this is going to have serious knock-on effects, Mark, in this situation, we would say, Mark, would you not be better off driving to Dundalk and using a local hub south of the border? You're in your Dublin employer's jurisdiction, you're in the Republic of Ireland. So you've essentially said, no, I'm not going to be in the north of Ireland carrying out my work, I'm going to be in the Republic of Ireland. Maybe using the likes of Creative Spark, which is great facilities. And in that sense, it means that although the employer is not in the office of his boss, he's in the country. And because he's in the country, he's detached from the UK rules, he's detached from anything to do with the national insurance rules, with the PE rules. There's no corporation tax liability. He has a single payroll still in the Republic of Ireland because he's now not working in the north of Ireland. He's left the north of Ireland. He's back into the Republic of Ireland. So as far as his taxes, they're all in the Republic of Ireland. Because they're all in the Republic of Ireland, it means now he's not having an additional tax liability in the UK. He still has a tax return to complete. Also, his employee benefits will all be in the Republic of Ireland. So if it's death in service and it's 4 times salary, it's his full salary, Republic of Ireland. His sick pay arrangements, redundancy calculations, everything for the employee will stay in the Republic of Ireland. His child benefit will stay in the Republic of Ireland because the 25% rule hasn't been broken. He's 100% of his time now either using the hub or he's in the office. So in this situation where it was going to be a lot of upheaval because of moving to the north of the border, that takes that away. And the rules basically state that if you're in the country, if you're across the border in the country of where your employer is, well, you're fully within the rules there. And I think this is where it could be flexible, where maybe Some employers are saying, no, we need you in the office. You have to be in the office all the time because we're worried about breaking the rules and we don't want to break the rules. So we're kind of being very stringent and taking everybody back to the office. This is, well, you don't need to take everybody in the office, just take everybody across the border. It also removes any issue with shadow payroll from employer point of view, from a cost point of view, and from the compliance point of view, that you're not then going to have any issues with it. So I think flexible approach, hub, relatives house, a base south of the border, if your employer is south of the border, and the exact same north of the border, really works well. I know when the circumstances where maybe geographically that's not possible, where the will have to be the shadow payroll, well then it's explaining exactly how the implications of it, how it's going to work, and how everything works. But I'm definitely a big fan of trying to simplify the processes, and certainly at the moment with the likes of the 25% rule being there, where it's very quick to change social insurance from one jurisdiction to the other, I think it's a better option in a lot of cases. Okay, take a breath, everybody. That was the world of the National Insurance and PRSI. Next part we're going to look at here is the employment side of things and employment law. And there's the question: which jurisdiction's law will apply? So we have the situation again. We'll take Mark back into the picture here. He's 2 days a week working in Newry, and he's maybe in that situation where he's meeting people in Belfast, he's then in Clones, he's back to Dublin, he could be moving all over the place. It's very important to establish, well, which employment law is it? Is it the UK law? Is it Northern Ireland law? Is it Republic of Ireland's law? What actual law is it? In the event of a dispute, the Dublin employer might well be sitting going, oh, well, sure, his contract was signed off here in Dublin, we're basing this on Dublin law. The employment solicitor might say in Newry, no, he is spending X amount of time in the north of Ireland, so we're going to use Northern Ireland law, which means that you're outside of the rules and regulations. So it's very important. We would strenuously advise any company to please speak to an employment solicitor to work out the ramifications of this. Figure out which employment law it is going to be and explain to the employee where they fall in this. And the more erratic the movement, I suppose, of the employee, the more difficult it is to figure out exactly which one it is. So while everything tends to go on swimmingly, it's all nice and great and no remarks passed, it's when a dispute arises that then there could be serious issues. An example again could be linked to maternity, and in a situation where somebody's expecting to be going off maternity at such a date, and under employment law in the north of Ireland might say you're entitled to so much time, and the employer in the Republic of Ireland say, well, we were expecting it to be so much time, or what your rights are when you want to return to work. What if you're not well? What if you're sick? What's the employment law rules about come back to work on either side of the border? So it's a small page, but it's a big one when it comes to trying to work out the what happens. And again, it is tricky because you're looking at laws on both sides and where does it merge, and it can be difficult to get it just very accurate in respect that the muddier the waters are with the work, and the more difficult it'll be. So a recommendation there is very much of an employment cross-border employment solicitor. And get everything sorted out. If there's a hybrid contract going to be put in place, have the facts done, have it worked out, and have it done correctly. With regards then to the procedures, if an employee wants to request flexible working, and they're coming to the HR department and they're sitting going, oh, I want to change my work, what happens and what are the procedures? And really, the north and south of Ireland, they're pretty similar. There's time scales involved, and you have to reply within so long, and you have to explain what you're doing, and there's different processes the employee has to go through, and there's different processes the employer has to come back with in return. And they're pretty similar, and they're very well laid out. There has been a lot of work done in these areas, and there's a lot of good, relevant information there. So for the Republic of Ireland, the Workplace Relations Commission have a code of practice, and it's for employers and employees, and it's the right to request flexible working. And that was approved in 2024 and works with the Work-Life Balance Miscellaneous Provisions Act of 23. Very much step-by-step processes are there, responsibility is there for employer and employee of what has to happen. And it is pretty straightforward, I have to say, from both sides of the border. There's a mechanisms there for it. And if we look back at the previous slides, this bit is nearly the straightforward part, in my opinion, in that whenever that employee would come and ask for this here, if they're a cross-border worker, I think this is then when you say, right, yep, okay, you want this, but let's look at all these areas. And then tell us if you still want to be a flexible worker, if you want hybrid work, and if you want to work from home, here's the implications for you. And here's a checklist for you to work out and see, are you still happy for us to start this process? So whenever that employee comes in and makes the request, that's the time I think that it should be said that it has to be, I suppose, looked at from their point of view. And it's up to the employee. If they look at everything and decide, no, I'm willing to change it and I'm happy to go ahead, then this process then kicks in. The important just on that too, that from an equality perspective, health and safety stays with the employer, regardless if that employee works from remotely. So you are still responsible. In the north of Ireland, as I say, it's quite similar in the same processes very much as the Republic of Ireland, and it's laid out to what has to happen. And under the Northern Ireland law, anyone can ask their employer for flexible working, but the law does provide that some employees have the statutory right to request a flexible working pattern. Now, there is big changes coming here, and it's again to bring in line the whole flexible working and the working regulations in the north of Ireland. And it's been proposed by our economy minister, Dr. Kiva Archibald. And there's been a consultation document known as the way forward. And they're saying that these proposals are going to result in the most significant upgrade of employment legislation in 25 years. So it's big changes. And it's going to be starting to come into law next year. And then there's going to be the implementation of it over the few years after that. And in the context of the flexible working and that there's a few adjustments going to be made to the rules. At the minute, you have to be in 26 weeks before you can request flexible working. And that's going to be taken away. It's going to be anybody who's working, be it new or existing employees, they all have the right to request to work flexibly. At the minute, you can have one statutory request a year, and that's being changed to 2 statutory requests for flexible working as well. There's also at the moment an employee requesting flexible working has to basically give the employer a solution to how it would work if they work flexibly. So if they're, for example, if they're working from home, they'll say, well, I'll be fit to do X, Y, and Z, and that'll not impact on the office, so it'll be okay for me to be working from home. With the new rules, there won't be the onus on the employee to explain how the employer would have to deal with it. So it'd be up to the employer to fix an issue if there was a problem of letting that employee work from home, where at the moment the employee would have to say, well, I could do this and this, or my colleague could do this, or we could switch hours to sort something out to accommodate the flexible working. But on the rules, pretty similar in what has to happen, and a pretty straightforward process to follow. And I think with these changes coming in next year, they'll probably come closer together as well with what they're doing. But again, my advice here is that when that employee comes in with the request, it's then that the employer probably will add value to that employee by explaining that there's potential implications for the employee and for the process then to be check out if everything's okay. First of all, if you're still happy to do it, well, then we'll look at it. Where if an employee then looks at the process, says, no, definitely not, I'm staying exactly as I am. I think you have potentially a more valued employee and he's happier to work in the workplace rather than in a hybrid situation because he knows that he's getting the most out of it. So important, I think, to bear that in mind. And when we talked about the cross-border world, we also have to cross the water, and the Great Britain and Northern Ireland with the Stormont Executives Good Jobs Employment Rights Bill and the Westminster's Employment Rights Bill, they're different. So there's going to be differences in both of these bills. So it's something to bear in mind as an employer. If you have a base in Liverpool and a base in Belfast, your employees will have different rights in both countries under these new bills. So I think from your employment side of things and the laws, make sure that you're up to speed on which ones would apply in which circumstances. And indeed, that would be the same if we bring in the Republic of Ireland. If we have the same employer has a base in Drogheda, and say we're using the 3 docks and they have a base in all 3 docks, again, it's the same. The Republic of Ireland's laws are going to be different again. So might seem a bit of a headache, but you will be having to monitor and keep a good tight eye on all 3 areas. But just it's something to note, a note for the future. Now, we're nearly there. We're nearly there. You can all relax now and take a breath. To conclude, and I hope you have seen this from several areas an employer to consider when considering to change the work practice of employees. There's impacts. There's impacts in their home life. There's impacts on their retirement. There's impacts on their children. There's impacts on sickness. And that's whenever there's a change to work practice. There's, we think you should be working from home, or we'd like you to work from home 2 days a week, or we'll accept that you do a hybrid contract. And vice versa, as we said there now, when an employee is coming in and saying, well, I want to change, I need to be at home, I want to be doing the school runs, and it's going to suit me for my childcare needs. So I think it's in the best interest of both parties to carefully plan for the future consequences of that decision. And it can only be done when all the available facts are gathered. And for the likes of ourselves here, that's what we will do. We'll look, we could spend 2 hours going through all the details of a person's situation to figure out what actually the actual impact is, what's going to happen down in 2 years' time, in 3 years' time, what happens if all these different eventualities we talked about occur. So if it's sickness, if it's death, if it's sickness in the family, what happens? So having access to relevant, accurate advice, we feel can help retain a very much quality workforce and prevent additional tax liabilities for the employer. So rather than maybe feeling that the only thing that you can do as an employer is allow for flexible working, it's maybe more a case saying, have a look at the situation, have a look and see, are you going to lose out as an employee by doing this? Even though it's not going to be an issue for yourself personally as an employer, but by protecting your workforce and giving them access to good advice or directing them to good sources of advice, that could be the difference in retaining that employee, because then they value the fact that what they thought was a good idea potentially isn't as good an idea, and they're glad then that they didn't go ahead and make that decision and then fall foul of all the consequences. And a good example of this is something that we would regularly deal with employers who are trying to get through this conundrum and trying to figure it out for their employees, and we would meet with the employees as well and discuss these here to get the solutions. There's a pharmaceutical company in Dundalk, it's PCI, and we have been working along with PCI, and what PCI are trying to do through their through the director, Niall McGinn, and through their head of HR, Tara Brady, are trying to ensure that their cross-border workforce is fully up to date with all the information to make proper decisions. And that can be, it's not so much linked to working cross-border in that hybrid working, it's more, are they getting the entitlements that they should be getting? Are they on the correct tax credits? When they come to work for the company, is the processes there to make sure that everything's done right and that there are correct tax codes? They understand what they should be doing. They understand what family benefit entitlements they have, understand if they're off work sick, what will happen on both sides of the border. And what we do now is we'll go in and we'll talk to their employees and we'll explain, where one thing in the cross-border world, there's always rumours and about what happens or what doesn't happen. And if somebody's believing a rumour rather than the facts, they can end up financially a lot worse off. And this is where the likes of PCI as an employer is saying, right, we'll protect our workforce, we'll add value to you as a workforce, because we'll make sure that you're getting proper advice and that whatever entitlements are there and whatever advice you need, you're going to get as a cross-border employee. Where the issue normally arises if anybody's working from a Dundalk base for a company in Belfast or vice versa, they'll not understand what happens on the other side of the border for that employee. And so they can't give them the advice, and they're scared to give them advice because it potentially could be wrong. And then they have an issue, where will they access this advice? So it's in that circumstance that an employee tends to make a wrong decision and there's a financial impact. So I think the likes of PCI and what they're doing, it's a great way forward, and it's a great idea, and it's making sure that the employer and employees are working well together, and it prevents then fallout and prevents issues and prevents a loss of quality, especially where it is very hard to recruit quality in such an area maybe that's nearly fully employed. So I think it's a great example of what can happen and how to work together on that. Now, that's my bit for now. We, as I say, we're Crossborder Solutions. We're based in Newry. We're in the Master's House in the old Abbey Yard here in Newry. If you need to get in contact with us for anything, please don't hesitate to do so. And what I'll do now is I'll pass you back to John.
Thanks, Martin. Thanks a million for your presentation. Much appreciated as always. Hope everybody found it very beneficial. Just what I'd like to touch on here is the supports that we provide as Intertrade Ireland. A couple of people have taken the opportunity in the chat there and used the link and applied for more specific bespoke one-to-one advice. All of those queries and those applications will be forwarded to Martin directly after the presentation, so he'll be in touch with you in due course to answer your more specific questions. And that leads us into what it is we're doing. We provide 2 levels of support. Level 1 through the Trade Hub is up to 2 hours of a phone call, fully funded, with a specialist in the area. And if the specialist can't answer the questions that you have within the 2 hours, they can refer you then for up to 3 days bespoke, fully funded advice up to a value of £2,000. We find a lot of businesses find very much great benefit out of using that facility with our specialists such as Martin. Our next trade series will be on commodity codes and rules and regulations in March, and it's live for applications and registrations on our website at the minute. Martin, we've just had 1 or 2 questions in the chat that maybe we didn't cover in it. Nuala had a question around Access NI checks and if they transfer to ROI.
Yeah, I'm not entirely sure. And most of the time, when you go to apply for a job in the Republic of Ireland, they'll want to carry out their own checks, and it can cause long delays. And it's something that we've been looking at with the likes of the Border People Project, and they've done work on this. It's trying to alleviate it. So, for example, if you're going to a job, say as a social worker in the Republic of Ireland, they might want to carry out their own checks and carry out their own processes, and maybe having to use Coru, and there can be a long delay in getting all the different references and all the different checks in that back. So I can't say for sure whether the Access NI transfers to ROI, but it's normally a case that they want to have their own checks done.
Perfect. Okay, thanks very much. Nuala, if you need anything further on that, maybe consider the application form. Annette was asking Martin, they're an employer that's registered and works both in ROI and NI. They have staff fully employed in both jurisdictions. One of the teams is based in ROI for most of the work, but they cross into NI from time to time. There's no fixed pattern to the work. They're a service company that work on client sites and with client demands. Should the days they work in Northern Ireland be paid through the NI company, or should it be paid through the ROI company?
Yeah, and I think Annette has hit the nail on the head here. It's a great question, isn't it? When you look at it, if you're trying to apply these rules to Annette's company, it's very, very difficult, isn't it? How do you establish, because they're, as you're saying, it's that erratic nature of the work. If you follow the rules, they'll say, well, if you're working in the north, you're meant to be in a payroll for the days in the north, and if you're in the days in the south, you're meant to be in a payroll in the south. But it's so difficult in this kind of a situation if it's an odd day here and there, and if things are moving about with their teams. But yeah, they're meant to have, it's meant to be the payroll rules applying.
Perfect. And then Sinead is asking, from an employee perspective, if they are resident in Northern Ireland and 100% work in ROI, do they need to do tax returns in Northern Ireland, Republic of Ireland, or both?
Yep, good question, Sinead. From an employee perspective, all employees, either north or south of the border, have a tax return, are due to do a tax return in the country that they live in. So if we have this situation that, say, if Sinead works in Uri and lives in Dundalk, and I don't know Sinead at all, but in that context, the revenue would expect a tax return to be completed south of the border if she works 100% of the time in the north, and vice versa. HMRC, if you live in the north, you have to complete a tax return in the north if you work 100% of your time south of the border. There's a slight difference in the rules here in that if you are working in Uri, for example, and living in the Dock, when you do your tax return, there is trans-border workers relief that you can claim. And it's a relief that if you're being taxed as a single person and that's the only income you have, you won't pay any more tax. That you already paid your tax in the north. It'll basically level off to zero. There'll be no liability. There would be a liability if you're taxed as a married couple. So if you're jointly assessed in the Republic of Ireland, you will potentially have a tax liability because your spouse may be taking some tax advantage of you in the south, and then that would lead to a tax bill. In the reverse order, it's a bit confusing all this, but somebody who is working in the Dock, living in Uri, they have to do a tax return to the HMRC. Our tax return deadline was literally 10 days ago, the 31st of January. And you have to declare your income from April to April each year. So that deadline of January 31st was for April 6th, 24 to April 5th, 25. And any income in that time has to be declared and paid for by the 31st of January. There is no mechanism with HMRC that if you that you wouldn't have a tax liability, you potentially can have a tax liability in the UK. Also, with the UK, you will be fined for not completing a tax return. And it's a big issue, and that a lot of people say, well, sure, I don't owe tax, so why would I bother doing the tax return? Not owing tax doesn't mean that the HMRC will say, well, you're grand, thanks for telling us. They'll fine you for not completing that tax return, and those fines can get very, very big very, very quickly. The other side of it is too, and it's something that did come out in COVID, is that whenever you decide that you're maybe going to start working from home, and this is where we had the issue in Derry, where we had a lot of the employees were in Donegal, were coming to work for the dairy companies, and they were told to work from home. But then Revenue said, well, that's on outside the Trans-Border Workers Relief rules because your work isn't carried out outside of Ireland. Those rules only work if the employee leaves the Republic of Ireland and goes to the north of Ireland to work. Then the Trans-Border Worker Relief comes in. But because they were working from home, they're back to being liable to tax in the south of Ireland in that context. So somebody working from home in the Republic of Ireland a couple of days a week and working for a UK employer will then have a tax liability in the Republic of Ireland, more than likely. So there's always a sort of a grey area with tax returns. They are meant to be done. You are meant to complete them. There is a slightly different set of rules comes into play with regards to then Article 18 rules, we call them. The other rules are Article 15 with the HMRC. Article 18 falls into then your public sector employees. So it can be somebody who is working as a nurse in Drogheda. It could be a teacher in Carlingford. Somebody, public sector, there is a slightly different set of rules that you can then go to the HMRC and argue the case that you do not have a tax return to do. It's not a sort of everybody's in the same situation and everyone's entitled to it. You're not. It's case by case dependent. It's very difficult to get it, and it's very difficult to get HMRC to accept that you do fall inside these rules. So we have people ring us up and say, but sure, I'm public sector, sure, I'm okay. You're not okay until the HMRC agree that it's allowed and that they have that noted. So it's something else to be very, very careful of. And also within those rules, if you're working from home under Article 18 rules, it means that you're outside of them. You are liable to tax. So anybody who has their HMRC exemption in place under the Article 18, if they're working from home, they are liable to tax for those days that they're in the UK working, say for the Louth County Council. The days that they're Louth County Council, they're okay, they're within the rules. So something to be careful of. It's not straightforward, but the rule would tend to be it's a tax return first and foremost, unless you have been told as a public sector worker, you're not. Everybody else, it is a tax return.
Okay, perfect. Thanks, Martin. Dominique is asking if an area manager who visits Northern Ireland once a month, but the rest of the time is in the Republic and they live in the Republic, but they have to be on dual payrolls, so they're only there one day a month.
Right. Yep. Yeah, Dominic, in this situation, it's okay. Now I have to get my head back into everywhere I am here, right? So they're they only visit Northern Ireland once a month. The rest of the time they're in the Republic of Ireland and they live in the Republic of Ireland. So if we put the rules in place, resident in the Republic of Ireland, work in the Republic of Ireland for a Republic of Ireland employer, and visit the north of Ireland once a month. So in that sense, the 60-day rule applies. The treaty rule applies. They're entitled to come to the north of Ireland for up to those 60 days without any changes. If that area manager had lived in the north of Ireland, then the rules would have changed. So in this context, we'll do the example if it's Dublin based and he's coming to see somebody in Banbridge once a month, that's perfectly okay. There is no issue with that at all. If your area manager was living in Banbridge, working for you, any day he's in the north of Ireland would be a Northern Ireland payroll. So that's the difference. The fact that they're living south of the border, they're perfectly fine. There is no call for dual payrolls at all. It's purely if they're living in the north of Ireland and come back to do work in the north of Ireland or vice versa. Does that make sense? Is that?
Yeah, perfect. Yeah, perfect. Thanks very much. Under the 60 days. Anne-Marie, thanks very much for your comment. We enjoy working very closely with you guys. Kieran, could Martin discuss issues where an employee lives in the Republic of Ireland and is provided a company car from a Northern Ireland employer?
Oh yeah, that's a sporty one. That literally very sporty. By right, if they are living in the Republic of Ireland, they work for a company in the north of Ireland and they have a company car from the north of Ireland, that's okay within the rules because that's part of their job and that's why they need the car. I think the issue is coming here for Kieran that if for example that employee is traveling in the Republic of Ireland and he's traveling on a Northern Ireland car for Northern Ireland company and he has a Republic of Ireland driving license, there's potential maybe if he is stopped with the customs, they can have an issue in this circumstance because they're saying, hold on, what's going on here? You have an address registered to Balbriggan and this car here is registered to a company in Downpatrick and your license is nothing to do with any of this. So it's a big area, and I know you've mentioned Anne-Marie there, something that Anne-Marie was trying to find more detail out on as well to try and discover what is the exact rules here. But by right, the fact it's a company car, it's not their car personally, that should be okay. But we have seen situations where there's been issues where they've been stopped by customs, and they're saying that they can't do this. From another, I think, point on this is that anybody who is driving their car across the border to work every day has to be very careful as well, because we'll find some of the insurance companies actually don't cover you to drive to work across border. And you have to be very careful and make sure that you're actually properly insured. Where with a company car, you tend to find that the company covers the insurance and it's covered for the island of Ireland, and it'll be done that you're okay there. It's often when it's your personal car, maybe, that you're driving to your place of work, be it the hospital or the school, and you have an accident. The insurance company mightn't be aware that you're leaving the UK to go to work in a different jurisdiction, and they don't automatically cover you to do that. They don't have to cover you to do that. You have to make sure that that company specifically does cover you. Another issue to be careful of is that with the cars, that your car insurance very often won't cover you to drive another vehicle to cross the border. And what I mean by this is, if your car is broken down and you get a lend of your brother's car and you can drive it perfectly legally in the north of Ireland, for example, with your own insurance, that insurance tends to stop when you get to the border, that you can't drive that car across the border. You also can't drive a car, for example, a Dublin Reg car, under your insurance in the north of Ireland. You're not insured under third-party insurance for that. So there is a lot of issues regarding cars and insurance, and it is a tricky area. So it's something that you have to be careful of, I suppose. But I think to go back, the company car, if you're working for that company, you should be covered. Okay, but there has been issues with it.
Okay, and we'll maybe take one more from Eileen, just conscious of time. If you live in Northern Ireland, you get your salary split between a Northern Ireland management company and a Republic of Ireland senior leader duties. Based on the time spent in each jurisdiction, the bonus relates to the management of the group. Does it need to be split between two companies in the same percentage? Not fully sure.
No idea. No idea at all. If it's a bonus, I don't see it. It's not the actual time spent, and maybe if it's relating to one part of the group. I've never came across that to see what if there was an issue with it. Mostly what happens is it's time spent in each area it's linked to. So it's more that.
I think, Eileen, maybe if you can fill out the application form, we'll maybe get a bit more specific advice for you on that one. Would be much appreciated. Okay, there doesn't seem to be any more questions in the chat from there. So just finally, reminder of our next webinar in March on commodity codes, rules of origin and classifying goods. Again, thank you to Martin for his presentation and answering the questions. And thank you to everybody for your attendance. It's greatly appreciated, the support that people give Intertrade Ireland in providing these. Thanks very much, everybody. Have a great day.